Hello everyone and welcome to this video tutorial in which I'm going to run through some evaluative points on occupier's liability for you. In your A-level law exam, you might get asked an essay question which requires you to critically evaluate the level of protection given by both the Occupier's Liability Act 1957 and the Occupier's Liability Act 1984. Now, I have got two separate videos on my channel which go through all of the rules and all of the cases on those acts, if you need a little refresher on that. But in this video, we're just going to look at what are the evaluative comments that you can make about the act in order to pick up those marks. Start off thinking about some evaluation for the 1957 Act. So OLA 1957 created a common law duty of care to all lawful visitors. And prior to this act, there were different duties owed to different types of lawful visitor, which, as you can imagine, was quite confusing. So this approach is fairer and more consistent. However, a really sort of strange thing about the 1957 Act is that in the Act itself, it looks as though it's going to give a definition of the occupier, but actually it just refers us to common law. And so we have to look at the case of Wheaton-Lacon to get our definition of occupier. And actually, occupier is a bit of a misleading term, we could say, because you don't have to actually occupy, as in live at the premises, in order to come under the Act. Occupier refers to having occupational control. Premises are also very broadly defined under the Act, and they include vessels, vehicles, and aircraft. And the fact it's broadly defined increases the chances of being able to claim successfully. Although a visitor is defined, it's very easy for a visitor to actually become a trespasser by exceeding the terms of their permission. So you could be a lawful visitor in someone's house to attend a party, you've got implied consent to be in the living room and to go to the bathroom, but if you decide to go and have a mooch about in the basement, you've exceeded your permission and have potentially become a trespasser. But the boundaries on when someone moves from a visitor to a trespasser are unclear. And so that's going to lead to uncertainty and inconsistency in the law and your ability to be able to advise your client on whether they're going to fall under the 57 or the 84 Act. Next point to make is that there's a special duty owed to children visitors under Section 23A of the Occupier's Liability Act 1957. And this seems fair because the Act gives extra protection to children who are the most vulnerable types of visitor. Cases on children and the Occupier's Liability Act, which you could talk about here, try to strike a balance between the responsibilities of the parents and the responsibilities of the occupiers, especially if the child is of tender years. So if you remember in the case of Phipps and Rochester, it was held that younger children should primarily be the responsibility of parents rather than of the occupier. But older children are less susceptible to harm than younger children, and we can have inconsistencies where the level of care is going to depend on the nature of the risk, the age, and the awareness of the child involved. And we've got this lack of certainty over what age a child is going to be classed as a child of tender years. And in the case of Jolly and Sutton, Lord Stein famously said that cases in occupier's liability are, quote, invariably fact sensitive. So in other words, the judge was admitting that really cases involving children are going to come down to the individual facts, which again makes it difficult to advise clients on the likely outcome of the case. It can potentially be seen as harsh in Jolly, harsh on the occupier, I should say, because the occupier was held liable in the case of Jolly, where two teenagers were injured messing about on an abandoned boat. And Really, you could say there, surely a teenager should know the risks of doing that. So it can sometimes appear a little harsh on our occupier. We should also consider the special rules that the 57 Act gives us on professional callers. And professional callers are tradespeople who come onto the property in order to carry out a job, such as an electrician doing electrical work. And the rule under Section 23B says that tradespeople should guard against the risks which are ordinary to their calling. And that rule seems fair because the tradesperson should have more knowledge of the ordinary risks involved than the occupier would. And you could talk about the case of Rolls and Nathan and the chimney sweeps there. So I've scrolled down slightly so that we can consider the special rules on the work of independent contractors under Section 24B of the 57 Act. And if you recall, an occupier is not liable for dangers created by independent contractors if the occupier acted reasonably in all the circumstances in entrusting the work to the independent contractor and took reasonable steps to satisfy himself that the work carried out was properly done and the contractor was competent. Now, in terms of evaluation, we could say that it seems fair to the occupier that we have this rule, and the fact that it's fair that we don't expect occupiers to check technical work. So you could use Hazeldine and Dorr as an example here. The occupier was not expected to check electrical work that was carried out on a lift. How could he possibly have done that? So that's a logical rule to have. It also seems fair, you could say, to expect the occupier to check non-technical work. So you could talk about Woodward and the Mayor of Hastings here. And in that case, the independent contractor was clearing snow off a step. And because that's non-technical and any person can look at a step and see if there's snow on it or not, it was reasonable to expect the occupier to have checked that. You could also discuss the fact that it's unlikely that our occupier is going to go about checking the insurance details and everything of an independent contractor. Now, our claimant, this rule should still be fair on our claimant because even if they can't claim against the occupier in occupier's liability, remember that they'll still have an action in negligence against the independent contractor. So they won't lose out because of this section. So again, that seems reasonable. We'll down a little further here to consider some other points. In terms of more evaluation, we could talk about the fact that what's the point of this act if liability can be avoided easily through warnings and exclusions. But remember that your rules on warning signs are that they need to be reasonable and they need to enable the visitor to remain safe. And usually they're not going to apply to children, and you can talk about the fact that that seems fair. Children may not be able to read, they may not understand the signs. In terms of exclusions, there are so many exemptions that they have limited use, but they do protect claimants and ensure that they receive compensation, and it's not too easy to avoid liability. And you could just briefly mention the Unfair Contract Terms Act so that the occupier can't have unfair exclusion clauses. In terms of defences, they're the same generally as for negligence, and on the whole they seem fair. You could talk about perhaps Tomlinson and Congleton, the guy who jumped into the shallow lake. He had been said to have fully accepted the risk when he did that, and that seems a reasonable conclusion if it's an adult of a sound mind. So let's consider some points we can make then about the 84 Act. And it's useful when you're coming on to evaluate the 1984 Act to briefly explain what the common law position was so that you can discuss why it was introduced in the first place. So prior to the Occupiers Liability Act 1984, the common law was extremely harsh on trespassers. And you could talk about the tragic case of Addy and Dunbreck, where a 4-year-old boy crawled through a gap in a hedge at a playground and was tragically killed on the defendant's land. And because he was technically classed as a trespasser, even though he's just an innocent 4-year-old child, his parents were unable to claim because he was a trespasser, and the law owed very little to people classed as trespassers. In BRB and Harrington, a duty of common humanity was found for trespassers, but the judges were unclear as to when the duty would arise and to its extent. So this ultimately led to the 1984 Act that provides a clearer answer to when a duty is going to be owed. And it is morally right that some protection is owed to people who are trespassing on land. But as you would expect, the duty to trespassers is restrictive. And it starts from the assumption that no duty of care is going to be owed. And there are 3 cumulative requirements for a duty under Section 1.3 of OLA 1984, and together they operate very restrictively, making it unlikely that a duty is going to be owed to non-innocent trespassers in most circumstances. And you could argue that this shows that the 1984 Act is carefully balancing the rights of occupiers and trespassers. You could also make the comment that there's no claims available under the 84 Act for damage to a trespasser's property. And obviously that seems fair. It's fair that we offer less protection to trespassers than we do to lawful visitors. So in terms of a conclusion then, you could talk about the fact that both acts were provided to give some clarity on when a duty is going to be owed to visitors and to trespassers. And the Occupiers Liability Acts of 1957 and 1984 are certainly an improvement on the common law, which was very unclear. However, both acts are drawn up in such broad terms and are so fact sensitive, as explained by Lord Stein in the case of Jolly, they can lead to unpredictable and inconsistent decisions, and it can be quite difficult to predict the outcome of any given case because of that. Okay, so I hope you found that video helpful. Please do have a look at the other videos on my channel if you need some help with how to apply the law on occupiers liability to a scenario question.